Okay, I'm assuming this is just a late indictment, even though it has 2023.
MTR. I think that's
It's on page 6. This is a motion to revoke.
There is a motion to revoke, but he also has several unindicted cases, Judge.
Are we proceeding on the motion to revoke?
Not at this current time, Judge. One discovery on the others. I mean,
Okay.
he has 1, 2, 3, 4 additional cases, and we had an opportunity to look at it today. I didn't really have an opportunity to evaluate those,
Mhm.
and I was hoping to get a small reset to look at that, because I think that some of them are going to be taken care of in an intake, and I just didn't want to hold that against him.
Okay.
Yeah.
So when do y'all want this recalled back?
Judge, I'm fine with next week. I've got 2 trial settings here next week, so you're going to see plenty of me.
All right. Do y'all want to recall this back for the 25th or the 26th or the 28th?
28th would probably be the best, Judge, so that we could get a little time just to, if that's okay, Mr.
Yeah, and that's one of the trial settings that I actually have. It's actually a discovery setting, Judge.
All right. So we will be back on August 28th to see what's happening with your other cases.
Thank you.
All right. Thank you. Do you have any questions about anything?
Oh, no.
All right. We'll bring you back on August 28th.
Thank you, Judge.
Thank you. Yes. Well, I mean, you may be excused.
I tried, Fred. Good.
All right. State, have you had a chance to review this motion for continuance that's being requested on Jeffrey Smith?
It was just, I just told about it, Judge.
Let me know if you have any objections.
Okay, Judge. I briefly went over it with the defense counsel, Judge. The state wouldn't be opposed to it.
All right. And you have no objection because it's not in the proper format?
No, I don't have any objection to that.
All right. Some people do. Jeffrey Smith. Cindy, we're going to go on the record. Okay. Court is calling 2025 CR 002103 State versus Jeffrey Smith. Can I have parties announced?
Jason Garahan for the state, Your Honor. Tilden Schaefer for Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
All right, defense, you filed a motion for continuance. Defense, you're aware that we have a jury trial scheduled, but you do not want to risk being called. Is that correct?
I have, Judge, I can't be 3 places at once as part of the law. And in part of what the motion is talking about is we have 2 witnesses in this case that we've been trying to get since June.
Well, I hate it. Well, I shouldn't say the word hate, but as a defense attorney, I never liked burning a motion for continuance if I didn't have to, but
I understand that, but the confluence of events in my practice, Judge, are necessitating this. It's an extremely delicate 36 hours for me. And I think my client deserves my undivided attention. I don't like burning it either, Judge.
yes.
This is classic courtroom.
This is a classic move in the courtroom. Defense attorneys often ask for a continuance, essentially a delay, when key witnesses aren't prepared or when their own workload is simply too heavy. But here's the twist. The lawyer openly admits he's in crunch time with his practice. That kind of honesty could work 2 ways. It might build credibility with the court.
I just think this is the prudent thing to do.
All right.
Or unless the judge is willing to say, we don't need it.
Well, I mean, I'm just saying that we have a jury trial that's scheduled this afternoon, and unless they enter a plea bargain agreement and I accept it, which I don't think they're going to enter a plea, that trial is going to go. And then there will be another trial that will be scheduled before your clients. But if you wish to continue with the motion for continuance, I, of course, will hear it.
Well, we confer on this 11th hour news, Judge.
Yeah. Okay.
We're going to continue with the motion, Judge. I've got to leave town in 42 minutes.
Okay. You have co-counsel here, but okay.
I understand that, Judge.
All right.
You hired both of us. I'm primary counsel on the case, Your Honor.
All right. So, state any objections to defense counsel's motion for continuance?
No, Your Honor.
All right. that will be granted. And then this case will be recalled. We can go off the record. When do you expect to continue with what you have in the other counties?
I'm not sure what I understand your question.
When are you going to be finished? You know, with the other counties, is that today thing or is that an all week thing? What is it?
I've got something tomorrow and that it's in the motion that I'll be most of the day tomorrow. And then Wednesday, I've got some personal issue, but that's, takes backseat.
All right. What we're going to do then is we're going to recall this back for August 25th for you all to obtain a jury trial date.
Yes, Judge.
To obtain a date or to
Yes.
be on? Okay. I just want to make sure because we've actually looked at our calendar.
Speak to me today. What's going on?
I am. Judge.
You understood? Thank you.
I just need to make sure I'm hearing what I'm hearing, Judge. I apologize for my density.
All right. So you're going to be back on August 25th. Could I have a reset form, please? Yeah. Once you sign the reset form, you're excused.
All right. Thank you, Judge. Appreciate it.
Your Honor, may we approach?
Yes.
We're back on Matthew Garcia. I told us to approach once we had everything resolved, and I think we do have everything.
Okay. All right. So are you all in agreement?
We are in agreement with the first motion for waiving the GPS fees, Your Honor. We're also in agreement with the second motion, which is to allow for partial for school. However, he does not have a school schedule yet, so.
All right. So let me ask this. With regards to waiving the GPS fees, are you retained?
Yes, Your Honor.
All right. So you'll need to place something on the record to show that he's indigent and he can't afford the GPS fees.
Yes, Your Honor. I'm ready to do that.
All right. And then let me read the other motions before we go on the record.
Yes, Your Honor.
All right. Court is calling 2025 CR 008995 State versus Matthew Garcia. Can I have parties announced?
Ashley Jones for the state, Your Honor. I apologize. May we step back for just 2 minutes?
Sure.
Thank you.
Sorry, Your Honor.
All right. Who's here on J. David Taylor?
I'm here, Your Honor. Ready?
All right. Mr. Taylor, if you'll come down.
My client is one of Louisiana's favorite sons.
Hey, everybody's favorite song. Probation. This is an application.
It's agreed to deferred. Okay.
Court is calling 2025 CR 008182 State versus J. David Taylor. Could I have parties announced?
Lauren Espinoza for the state of Texas.
James Seeloff for the defense.
And are you Mr. Taylor?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Taylor, did you review the application for deferred adjudication with your attorney?
Yes,
You know the
ma'am.
difference.
Yes.
This is the document that says that you want court to consider you placing you on community supervision or probation.
Right.
Did you review that with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment that tells what you're charged with?
Yes, ma'am.
Did you understand it?
Yes.
This is the turning point. The judge lays down the harsh truth. Robbery isn't measured by the price tag of what's taken. Even something as small as a pack of Clorox wipes can cross the line into felony territory if force or physical contact is involved. The message is clear. It's not about the object.
Counsel, do you waive the reading of the indictment?
Yes, we waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Taylor, did you review the admonishments that tells you what you're charged with, what your plea bargain agreement is, and what rights you have? Did you review that with your attorney? Did you understand it?
Yes, ma'am.
You're charged with the offense of robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea agreement with the state, The court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, thoroughly.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They'll take in consideration 2025 CR 008183, and there's to be restitution, if any, to the Dollar General store. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's our plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the Dollar General and with Erica Aguilar. Did you understand that to be recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers what has been marked as State's Exhibit 1 in all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, and we waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, the item that was taken in the store was returned to the store. So as far as restitution, there is none. And there's a TIC of the evading arrest, Your Honor, as part of the plea bargain. And I just got the motion for dismissal. My client, whereas he is homeless at the current time, he does have employment opportunity through the nursing industry. Is that correct?
Oh, I don't allow that. While you're on while you're on probation and felony probation in this court, I don't allow people to work as home health care providers.